Good morning. There was an opinion reprinted in the New York Law Journal of Wednesday, September 3rd, 2008 that I thought you'd be interested in. And the headline given to the opinion pretty much sums up the case. Homeowners may proceed with a breach of fiduciary duty claim against a reverse mortgage broker. Importantly, the law with respect to mortgage brokers is the same as it is for insurance agents, so I thought you'd be interested in this case. The case is Iannuzzi versus Washington. The plaintiffs are Anthony and Teresa Iannuzzi, who lived out on Westbury, Long Island. In about 1990, the Iannuzzis had this fella Dawson prepare their income tax returns. 10 years or so passed, and at some point, Dawson became their investment advisor managing their money. About 2005, 2006 or so, it was decided that a reverse mortgage would be in the Iannuzzis' best interest. So Dawson introduced the Iannuzzis to this other fella that had been putting together reverse mortgages for other clients of Dawson. And they went through the reverse mortgage process. Part of the Iannuzzis' claims here, and the Iannuzzis are suing Washington Mutual Bank, and a half a dozen other defendants were sued as well, and or brought in the case by Washington Mutual Bank. A lot of intermediaries here. But the plaintiffs are alleging breach of contract, misappropriation and conversion, fraud, and misrepresentation, and breach of fiduciary duty. So a lot of issues are being alleged. We're just talking about the breach of fiduciary duty claim here. The plaintiffs are alleging, among other things in their complaints, that during their communications with CCC, who's one of the defendants, during the communications, plaintiffs were asked a limited number of superficial questions that did not encompass the scope of information or documentation that would be required to fully complete an application for a mortgage of any kind. So what are they alleging here in the complaint? That a fact finder wasn't done. Just some superficial questions, no detailed fact finder. The plaintiffs further allege there was looks like a .5 mortgage origination fee and a $450 application fee, another small fee. So those seem in line, right? It was a $300,000 loan. But also at closing, the Iannuzzis paid $6,300 in a deferred broker premium. What is that? So one of the allegations is the plaintiffs allege that the existence of these exorbitant premiums is an indication that the product which was selected was not selected because it was most suitable for the Iannuzzis, but because it generated the highest commissions. And we'll see this is an important element. It turns out the transaction went through. There was a closing. And the closing, though, was not for a reverse mortgage, but for a conventional 30-year loan for $300,000. At the closing, the Iannuzzis were given one check for $3,600, which represented supposedly the first month's payment on the reverse mortgage. And then they got one or two other checks. And then at some point, one of the checks that they were getting from a company controlled by Dawson and or the reverse mortgage broker, that check bounced. And at the same time, they got a letter from Washington Mutual Bank, hey, you're behind on your mortgage. And so then it was discovered that this was not a reverse mortgage, but a conventional 30-year loan, of which the defendants, Dawson and the mortgage broker and some of the other smaller intermediaries, walked off with the proceeds. So that was a problem, and so the suit against WAMU and these various other intermediaries on these claims. It's important to understand that what we're looking at here is an opinion deciding a motion for summary judgment or a motion to dismiss, meaning a lawsuit was brought by the plaintiffs, the Iannuzzis. The defendants, Washington Mutual Bank and CCC, asked the judge, hey, dismiss this complaint. There's nothing here. We shouldn't have a trial. Dismiss the case, judge. And so they made a motion for summary judgment. And for the purposes of deciding this motion for summary judgment, the court is bound to accept as true the allegations made by the plaintiffs in their complaint. It may turn out, therefore, that the facts that I've just articulated are completely incorrect, didn't happen at all the way the plaintiffs say that it happened. So keep that in mind. Continuing, and so now the court lays out in his opinion on the breach of fiduciary duty. The defendants are saying that the claim for breach of fiduciary duty must be dismissed because there was no fiduciary duty between the mortgage broker and the Iannuzzi's. The court says on this point the court disagrees, and at this time the motion to dismiss cannot be granted based on the allegations that the plaintiff made. Under New York law, there are two elements to a breach of fiduciary duty claim. The first is that there has to be a duty in the first place, which is the critical point, and two, that there was a breach of that duty. Now the court goes through the law on fiduciary duty. The determination of whether a fiduciary duty exists cannot be determined by recourse to rigid formulas. When examining whether a fiduciary relationship exists under New York law, a court examines whether one person has reposed trust or confidence in the integrity and fidelity of another, who thereby gains resulting superiority of interest. A fiduciary relation exists between two persons when one of them is under a duty to act for or to give advice for the benefit of another upon matters within the scope of the relation. New York courts have generally held that a fiduciary duty does not exist between mortgage brokers and borrowers. Under New York law, generally, there is no fiduciary duty inherent in an ordinary broker-customer relationship. And here the court is citing a case where the broker was not a mortgage broker but a stockbroker. Continuing, insurance brokers and companies generally do not owe a fiduciary duty to those they insure. No fiduciary duty. Let's make sure we're on the same page with respect to our use of the word fiduciary. Fiduciary is a general word which applies to a specific relationship, a specific type of relationship between two persons or a person and an entity. And that specific relation as fiduciary under law requires the person acting as fiduciary to put the principal's interests above their own. It's a special relationship that's long been recognized in the law. For example, an attorney in fact is a fiduciary with respect to their principal. The executor of an estate is a fiduciary. The trustee of a trust is a fiduciary. Those persons are in a special relationship with their principals, and the key element is that fiduciary is bound by law to put their principal's interests above their own, which is why it was so important in the complaint that the Iannuzzi's alleged that the product that was chosen by the broker wasn't the most suitable product, but the one that paid the highest commissions to the broker, and that was a breach of fiduciary duty. Of course, walking off with the mortgage proceeds was also a breach, but most importantly for our case, that it was the product was not suitable. It was chosen for the high level of commissions, and when there's a fiduciary relationship, that cannot occur. Generally, right, suitability is the standard by which insurance agents are judged on the recommendation of products to their customers. The court continues, the dispositive issue of a fiduciary-like duty is determined not by the nomenclature, the words finder or broker or agent. That's meaningless. The dispositive issue of whether there was a fiduciary relationship is the services agreed to and the actual relationship between the parties. What was the conduct of the parties, the conduct of the broker or agent with respect to their client? Does the totality of that conduct rise to the level beyond the traditional role of a broker? In this case, the court finds that at least the plaintiffs have alleged sufficient facts to show that the mortgage broker went beyond the traditional role of a broker, took on additional duties which the e-newsies relied on, and that is what caused the fiduciary relationship to develop, and therefore whether there was a breach of that duty is a matter, of course, that has to be found at trial. So, is this part of some national trend or not? I don't know. Certainly we've seen more instances in New York and nationally with respect to fiduciary relationship being alleged by plaintiffs when things have gone south in the market, for example. Point is, traditionally no fiduciary duty among insurance agents and their clients. However, when the agent starts because and the client is relying on that advice under New York law, that relationship could rise to the level of fiduciary, and the agent held liable for any errors with respect to not putting the client's interests above their own. So what does that mean? Subject of another segment. There are some more opinions that I wanted to tell you about, but for now, good luck.